Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our 55th and 56th lecture series. Today we have gathered to discuss about a landmark judgment that is prescribed in our AOR syllabus also. Lecture number, serial number 84, ALIGARH Muslim University case. But before going to touch upon the topic, it is our regular practice that we recite preamble before we begin our session. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation in our Constituent Assembly this 26th day of November 1949 do hereby adopt, enact, and give to ourselves this constitution. Dear friends, we strongly believe that every citizens of the country must endeavor to bring what are the goals enshrined in the preamble into real terms. So that is why we strongly believe that preamble our goal, preamble our soul, preamble our commitment, preamble our sentiment, preamble our dignity, preamble our unity. So with this noble thought, let us start with our leading case. This is leading case number 84, and we have already dealt with the majority view of this case. Now we are going to see the minority view of this judgment. So there were 7 judges. This case was decided by 7 judges bench. The majority is on the one side, that is 4 judges. Minority, that is 3 judges on the other side. So the videos that what we have uploaded, that is already there with respect to the majority view. Video number 53 and 54. Now we are going to deal only with the minority view. In the minority view, it was delivered by 3 honorable judges. Honorable Justice Suryakant, my lord, Honorable Justice Dipankar Datta, my lord, and Honorable Justice Satish Chandra Sharma. So these lordships, in their wisdom, they have given a minority view on the judgment by giving their own interpretation, erudite judgment. So now we will be dealing with 2 lectures, lecture number 55 followed by lecture number 56. So in lecture number 55, I will be dealing with minority view by Honorable Justice Suryakant ji, and 56 will be dealt with the minority view delivered by Honorable Justice Dipankar Datta and Honorable Justice Satish Chandra Sharma. This is what I have proposed to do, dear friends. Now let us focus on the minority view delivered by Honorable Justice Suryakant ji. So what is this judgment is all about? The judgment is all about what are the principles, what is the test to identify whether ALIGARH Muslim University is a minority institution or not. What are the principles? So which article revolves around this test? That is Article 30, Clause 1 of the Constitution of India. What does it say? Article 30, Clause 1. All minorities, whether based on religion or linguistic, shall have the right to establish their educational institutions of their choice. So this is what Article 30, Clause 1 says. Now, in the minority view, the first question is with respect to the reference, how this matter has reached 7 judges bench. The history that we need to know, for which we have to see 2 cases, dear friends. Anjuman-e-Rahmaniya, 2 judges bench. Please note down how many judges also. That is very important, because it involves doctrine of judicial discipline, judicial propriety. So 2 judges bench, Anjuman-e-Rahmaniya, in this judgment, the honorable judges doubted the correctness of the judgment of the Constitution bench comprising of 5 judges in Ajit Basha case. So 2 judges doubting the correctness of the 5 judges. The 2 judges referred the matter to the Honorable Chief Justice of India to constitute a bench greater than the 5 judges bench, meaning thereby indicating the numerical strength of the bench where the Honorable Chief Justice is supposed to constitute. Now the question before this majority or the minority, the bench, was whether referral by 2 judges bench to the Chief Justice of India pointing out the numerical strength, does it violate the master of the roster, where the Honorable Chief Justice has the authority to decide how many judges will decide this case and who are all the judges will decide this case, when, what, everything will be decided by the Chief Justice of India. So therefore 2 judges bench pointing out the numerical strength, that means do they violate master of the roster, questioning the Chief Justice of India's authority, and then violating Article 145 and Supreme Court rules, Order 2, Order 7, Rule 2 of Supreme Court rules. So these were the questions before this larger bench. According to Honorable Justice Suryakant, my lord, has said that reference is bad in law. Reference by 2 judges questioning the correctness of the 5 judges, pointing out to the Chief Justice of India to constitute the greatest strength, that means it is questioning the Chief Justice of India's authority. Therefore 2 judges have violated the master of the roster principle, and they have not followed judicial propriety. There are certain judicial standards is to be maintained. If they do not do so, that means 2 judges bench have committed multiple illegalities. The term used is illegalities and judicial impropriety. That means it is not up to the judicial standards, professional standards. So everything cannot be questioned by everyone. So therefore, how to make referral? It is dealt in Bohra community case. On the last occasion, we have dealt what are the principles in the Bohra community when 2 judges can refer to the larger bench. So everything is pointed out there. But according to Honorable Justice Suryakant ji, my lord, has said referral is bad because the 2 judges bench cannot quote the numerical strength It is like questioning the Chief Justice of India's authority. Then how this judgment was delivered? Because the reference went under two ways, dear friends. One way is Anjuman-e-Rahmaniya referring the matter to the Chief Justice of India to constitute a bench of particular strength. That is bad. But another reference was also there. That another way was in ALIGARH Muslim University, they have prescribed 50% reservation for Muslims community for PG medical course. That was challenged. So single judge of Allahabad High Court has rendered a judgment by saying ALIGARH Muslim University is not a minority institution. The Honorable Single Judge relying upon Aziz Basha case, because in Aziz Basha case they have held ALIGARH Muslim University is not a minority institution because it was not established by the minority. It was created only by the Muslim ALIGARH University Act. So it was a creature of a statute. So therefore, the single judge relied upon Aziz Basha case, and against that order, the matter reached the division bench of the Allahabad High Court and then reached the Supreme Court, comprising of 3 judges. One of the Chief Justice, Honorable Chief Justice, the then was Justice Ranjan Gogoi. My Lord has referred this matter to the 7 judges bench. So, 2 ways of reference to the 7 judges. One is through Anjuman-e-Rahmaniya. Another one is from Allahabad High Court, culminated into reference before Chief Justice, where Chief Justice Ranjan Gogoi, my Lord, has referred the matter to the 7 judges bench. So, in this judgment, ALIGARH Muslim University, comprising of 7 judges, Justice, my Lord Suryakantji has said that reference by the Chief Justice, by Justice Ranjan Gogoi, was correct. Because he was the Chief Justice. He was the master of the roster. So he has complete authority to refer the matter to the larger bench. So therefore, that reference was correct, but not the reference made by Anjuman-e-Rahmaniya, that was bad in law. So this was the finding by Honorable Justice Suryakantji in this reference is concerned. Coming to the next point, whether Article 30 Clause 1 that falls under Part 3 of the Constitution of India, and Constitution of India was adopted in the year 1949 and enforced in the year 1950. But ALIGARH Muslim University was established in the year 1920s. So the question was whether can we apply the protection or under Article 30 Clause 1 can be extended to an institution which was established prior to the Constitution, pre-constitutional era. That was the question. But Honorable Justice Suryakantji in his wisdom has said that we can give protection. An institution which was established prior to the Constitution will also get the protection under Article 30 Clause 1. We cannot have 2 different minority institutions or 2 different institutions where the institution established post-constitution will get the protection, pre-constitution will not get the protection. That is bad. Such classification cannot be made. So His Lordship has said Article 30 protection will be available to an institution which was established even before the Constitution of India. Right? This is clear, dear friends. Now coming to whether Aziz Basha, the correctness was questioned. The majority view authored by Honorable Chief Justice of India, Honorable Justice Dr. D.Y. Chandrachud, his Lord, has said Ajit Basha was overruled by the majority. What about this minority view? They have clarified to certain extent. What is that extent? Let me take you to the relevant paragraphs, dear friends. It is 190B and C of the relevant paragraphs of the judgment. 190, 190B and C. Whether have they overruled, have they modified, but in this case they have only clarified. I am reading para 190 of the original judgment, Aziz Basha. Aziz Basha, however, seems to be erroneous to the extent, see, they are saying it is erroneous to the extent that means what? That means they are not overruling the entire judgment. They are questioning that Aziz Basha, however, seems to be erroneous to the extent it holds that since Section 6 of the ALIGARH Muslim University Act 1920 provided that the degrees conferred by the university would be recognized by government. Consequently, an institution was brought into existence which could not be brought into existence by a private individual or body. Aziz Basha might therefore not be correct. Aziz Basha may not be correct in its entirety and as a general principle of law to hold that even if the Aligarh Muslim University Act 1920 was passed as a result of the efforts of the Muslim minority, it does not mean that the Aligarh Muslim University, when it came into being under the 1920 Act, was established by the Muslim minority. And one more paragraph, dear friends. In this context, it is our considered opinion that the establishment of a university, whether as a minority institution or as a religion neutral institution of high standard, is a complex and mixed question of law and fact. The legislative intent behind the establishment of a university or an institution will have a significant role in determining the status of an institution. So therefore, they have said to a certain extent, Aziz Basha is erroneous to the certain extent, but not fully. So the reference in Anjuman to a 7-judge bench for the reconsideration of the 5-judge decision in Aziz Basha is bad in law and ought to be set aside. This is the conclusion. Thereafter, the Constitution bench in Aziz Basha, when it holds that since Section 6 of the AMU Act 1920 stipulates that degrees conferred by AMU would be recognized by the government, it could not have been brought into existence by a private individual or body seemingly incorrect. Accordingly, and for reasons assigned in paragraphs 190 clause B and C, the said decision to that extent is hereby modified and clarified. So it is not overruled, it is modified and clarified to this extent. Now, coming to the most important aspect, that is Article 30 clause 1, which deals with two terms, dear friends. One is establishment and another one is administration. So what is establishment and what is administration? That is discussed by the minority view. The true import, please note these two terms. The true import and meaning of the expressions establish and administer, which comprise the very core of Article 30, are to be construed and understood strictly in accordance with the indicia in paragraphs 141 and 181. In this minority view, my lord is expressing that to understand what is establishment, to understand what is administration, that we have narrated in paragraph number 141 and 181. What is 141? Let us read, dear friends. So the courts have to consider whether it is what is establishment means. The genesis of the constitution, the genesis of the institution and who conceptualized the idea, the gathering of resources and who provide the requisite finances for creating the institution, who contributed towards the infrastructure of the institution to provide it with a physical existence, the framing of chartered document and who imparted the purpose to the institution. In case government approvals were required, who made the initial efforts in taking those permissions and fulfilling the necessary compliances, and post the approval of the government, who undertook the initial steps in forming the administrative bodies, hiring teachers, admitting students, passing the first statutes and ordinances, ensuring regular compliances, etc., for operationalizing the institution. So this is what the test to identify whether it was established by the minority or not. Majority view, we understood by the majority view that IPI. What is IPI? Idea that establishment of the minority institution must come from that minority community or an individual. So the idea must be born out of that minority. If a Muslim wants to establish a Muslim university, that idea has to come from that particular Muslim person, not from any other religion. So idea must be coming from that concerned person, idea. What is the purpose? P stands for the purpose. The purpose is to benefit the Muslim community at large. It is not exclusive, but predominantly it must benefit the Muslim students. IP. What is next I? Implementation. How it is implemented? By whom it is implemented? It is implemented by the minority, that is Muslim community. The resources, the funds, that has to be organized by the Muslim community. The infrastructure that has to be put up by the Muslim community. So this is why we say it IPI, idea, purpose and implementation. All three must be done by that minority community. Then only it will become minority institution. So similarly, here also Honorable Justice Suryakant, my lord, has said about the idea, purpose and implementation. But where they are differing, where the dissenting is, that is with respect to the administration. Because as per the majority view, establishment is sufficient. Administration can be done by any efficient person from even from any community also, provided they do not affect the characteristics of minority. That was the majority view. But as far as the minority view by Honorable Justice Suryakant, my lord, is concerned, establishment and administration has to be read together, conjunctively. It is not a single test, it is a twin test. Majority view says, once it is established by minority, that is sufficient. Administration comes as a consequence of the establishment. Therefore, administration cannot be a precondition to test whether it is a minority institution or not. That is what the majority view is. So, majority view is a single test, only establishment, not the administration. Administration can be done by any community. But as far as the minority view rendered by Honorable Justice Suryakant ji, my lord, is establishment by minority and administration by minority, it is a twin test to qualify whether it is a minority institution or not. Hope it is clear, dear friends. So how to test whether this administration is best with the minority or not? The test is explained in para 181, dear friends. Now we have seen the test for the establishment. Now for the administration is concerned, para 181. Illustrative factors. Please note down this paragraph, dear friends. Para 181. Illustrative factors which are likely to take away administration of minority community from the institution. So what they are saying is, they are not saying the positive view that what will amount to the administration by the minority, but negatively what they are saying is what will not constitute administration by the minority, what will not constitute administration by minority. Let us see. Management staff is not answerable to the founders. Management staff is not answerable to the founders, or an external person has veto over their selection. So generally the founders are the minority. Management should be bound by the decision taken by the founders. If management says that we will not listen to the founders, that means it is not a minority institution. The lack of control over such selection would have significant weight, since it is a post of prime importance around which administration revolves. He or she is a hub on which all spokes of the institution's wheels are set around. So the administration, or like the lack of control over such selection would have significant weight, since it is a post of prime importance around which administration revolves. He or she is the hub on which all spokes of the institution's wheels are set around. That is first. Number two, this is second illustration. There are outside authorities in the governing body of the managing committee with wide powers over the other members. So they have wide powers over the other members. That means it will not amount to minority institution. Minority community, this is third illustration. Minority community does not have any right over determining the overall fee structure of the institution. If the minority community is not able to decide what is the overall fee structure for the students, then it cannot remain as a minority institution. Minority community does not have final say over administration, such that over the management committee comprising of the members of the minority community, there is an appeal to an outside member. Fifth illustration is, minority community does not have any say over the medium of instruction. 6. Regulation prescribes reservation for unaided minority institutions. 7. Minority community does not have the right to choose the governing body and to choose teachers or admit students. Removal of an employee, this is 7th point, dear friends. Removal of an employee requires the approval of an outside member who has the discretion to withhold such consent. The minority community does not have a say in the appointment of administrative authorities of the university, such as Vice Chancellor, Pro Vice Chancellor, Registrar, etc. The minority institution entirely depends on government aid. That means it is not a minority institution. The minority community does not have right to deploy properties and assets for the benefit of the institution. So, His Lordship, Honorable Justice Suryakanji, my Lord has stated what is establishment and what will not amount to minority institution by pointing out the illustrations. So, according to my Lord, the conclusion says, so the true import and meaning of expressions establish and administer, which comprise the very core of Article 30, are to be construed and understood strictly in accordance with the indicia, that is indication, given in paragraph 141 that deals with the establishment and 181 which deals with the administration. Now the next question is the question pertaining to whether AMU satisfies the above mentioned test of establishment and administer so as to seek the protection of Article 30 of the Constitution, and which will concomitantly entail a mixed question of facts and law, will be determined by a regular bench. The reference is answered in the above terms, ordered accordingly. Now, His Lordship, in his minority view, has set out the principles how to test whether AMU is a minority institution or not. The principles are laid down. Look at the establishment, that there should be idea must come from that minority, that purpose for the benefit of the Muslim community, implementation by the minority, and administration, they should have entire control over the administration. The minority community should have the right to choose the teachers, to choose the medium of instruction, to choose the fee structure for the students. So if they are unable to do it, then it will not amount to a minority institution. So that is the test, dear friends. Now the honorable judge have said that we have laid down the test, we have laid down the principles. Now it is up to the regular bench to test whether AMU, that is ALIGARH Muslim University, will qualify this test and then will get a protection under Article 30 Clause 1 or not. That is a test to be determined by the regular bench based on the principles enumerated by them. So this is what according to the minority view of Honorable Justice Suryakanji. Hope it is clear, dear friends. Let me sum up the minority view of Honorable Justice Suryakanji. First is reference is bad by the two-judge bench in Anjuman-e-Rahmaniya to the Chief Justice by quoting the numerical strength that is greater than the Constitution bench. That is bad in law. Article 30, which protects the minority institution rights, that is available, that protection is available even to the institution which was established before the Constitution. Number 3, Ajit Basha, though it was overruled by the majority, but Honorable Justice Suryakanji, my lord, has said it is erroneous to the certain extent, therefore they have clarified. Fourth is very important test, the interpretation of the two terms provided in Article 30 Clause 1, that is establishment and administration. They have described what is the test to determine whether it is established by the minority and what is the administration by the minority. So those are the principles laid down by the Honorable Justice Suryakanji. Thank you so much, dear friends. With respect to lecture number 55 is concerned,